Hello and welcome to Courts Today by Live Law. Let us get to today's top legal updates. West Bengal government has approached the Calcutta High Court challenging life sentence for the RG convict and calling for death penalty. The Supreme Court has sought Delhi Police's response on Tahir Hussein's plea for interim bail for the Delhi elections. In the Deoghar Airport case, the Supreme Court has affirmed quashing of FIR against BJP MPs and has asked the Aircraft Act Authority to decide on filing complaint. The Supreme Court today asked the High Courts to form committees for service conditions of District Judiciary within 4 weeks regarding implementation of the Second National Judges Pay Commission. The Supreme Court has dismissed ED's plea to cancel bail of former Maharashtra Deputy Chief Minister Chhaggan Bhujbal in the money laundering case. And the top court has granted interim protection to Congress MP Imran Pratapgarhi in an FIR over Instagram clip with the poem titled "Ae Khoon ke Pyase Baat Suno." I'm your host Urvashi with your daily roundup of legal updates from across the country. Let us start. Starting with an important update, the West Bengal government has approached the Calcutta High Court demanding death penalty for the convict in the RG rape and murder case who was sentenced to life imprisonment by the Sessions Court. The court had held that case did not fall within the rarest of the rare category. After the sentence was pronounced yesterday, people on social media demanded capital punishment for the convict. Chief Minister Mamata Banerjee on her X handle criticized the verdict and vowed to appeal against it before the High Court. Notably, Sessions Judge Anirban Das in his verdict had also raised objections on the lapses by the police while conducting the investigation as well as attempts by hospital authorities to cover up the issue. The Supreme Court has sought a response from the Delhi police regarding a plea by AIMIM candidate and Delhi Riots accused Mohammad Tahir Hussain, who is seeking interim bail to campaign for the upcoming Delhi Assembly elections. Hussain, currently in custody, has approached the Supreme Court after being denied interim bail by the Delhi High Court in a case related to the death of IB staffer Ankit Sharma during the 2020 Delhi riots. A bench comprising Justices Pankaj Mittal and Ehsanuddin Amanullah heard the plea today. His counsel, senior advocate Siddharth Agarwal, argued that Hussain has been in custody for nearly 5 years on charges of inciting a mob during the riots. That he is accused in 11 cases but has been granted bail in 9. The 2 cases where he remains in custody include charges under the PMLA. Agarwal pointed out that Hussain has not tried to obstruct justice and highlighted that the main accused in the case have been granted bail. The bench expressed reluctance to grant interim bail but did not dismiss the possibility of a regular bail. Justice Amanullah noted that Hussain has been granted bail in other cases with similar allegations and questioned why interim bail could not be considered if there is a case for regular bail. The court has sought response from the Delhi police and the hearing will continue tomorrow. Stay tuned. In the next update, the Supreme Court today dismissed the state of Jharkhand's appeal against the High Court's decision to quash an FIR against BJP MPs Nishikant Dubey, Manoj Tiwari and other persons related to the 2022 Deoghar Airport incident. The FIR filed in September 2022 accused them of threatening and coercing air traffic control officials to authorize the takeoff of a private aircraft, allegedly violating safety regulations. The FIR that was quashed by the High Court invoked sections of IPC including Section 336, that is endangering life or personal safety, Section 447, criminal trespass, and Section 448, house trespass, as well as Sections 10 and 11A of the Aircraft Act, which deal with penalties for wrongful acts related to aircraft and allowing government to detain aircraft for safety and compliance investigations, respectively. The Jharkhand High Court had dismissed the FIR because it did not meet the specific requirements set by the Aircraft Act, such as an official complaint or authorization. The High Court had also determined that rules of Aircraft Act override the general provisions of the Indian Penal Code. Before the Supreme Court, the state argued that prior sanction was not required for the investigation under Section 10 and 11A of the Aircraft Act. The court noted that cognizance of offences under the Aircraft Act could only be taken upon filing a complaint. It questioned the applicability of certain IPC provisions in this case, particularly Section 336 and Section 447, citing lack of clear evidence that lives were endangered or that criminal trespass occurred. A bench of Justice Abhay Asok and Justice Manmohan dismissed the appeal but granted liberty to the state of Jharkhand to forward the materials collected by them during investigation to authorized officer under the Aircraft Act within 4 weeks, and such officer was directed to take a decision in accordance with law as to whether a complaint needs to be filed under the Aircraft Act. In the next update, the Supreme Court today urged all high courts to ensure the constitution of Committee for Service Conditions of the District Judiciary in terms of directions issued in the All India Judges Association case in January 2024. These directions were issued to deal with the grievances of judicial officers regarding implementation of Second National Judges Pay Commission. A bench comprising Justices B.R. Gawai, Augustine George Massey and K. Vinod Chandran passed the direction after being informed by Senior Advocate K. Parameshwar, the amicus curiae in All India Judges Association case, that many high courts are yet to constitute the committees. He noted that even in high courts where committees have been established, they are not meeting regularly, leading to judicial officers bringing their individual grievances directly to the Supreme Court. Additionally, he said many high courts have yet to appoint nodal officers for these committees. The bench pointed out that these committees were intended to prevent the Supreme Court from being overwhelmed with such applications. It emphasized that if the January 2024 directions are fully implemented, many issues can be resolved by the committees themselves. The court directed that the nodal officers of the committees who are required to be a retired district judge be appointed within a period of 4 weeks. Further, the court also urged the High Court judges to record annual confidential reports or the ACRs of judicial officers promptly so that they do not lose opportunities of promotion, noting that ACRs of many judicial officers were getting delayed. In the next update, the Supreme Court has today dismissed pleas by the Enforcement Directorate seeking bail cancellation of former Maharashtra Deputy Chief Minister and current NCP MLA Chhaggun Bhujbal and his nephew Sameer in a money laundering case connected to the Maharashtra Sadan scam. Bhujbal was arrested in 2016 following allegations of money laundering linking to the alleged irregularities in awarding contracts for construction of Maharashtra Sadan in Delhi and Kalina Library at Mumbai University during his tenure as Maharashtra's Public Works Department Minister. A PIL filed by the Aam Aadmi Party in 2014 led to establishment of a special investigation team. In May 2018, the Bombay High Court granted bail to Bhujbal, imposing several conditions including surrendering his passport and not leaving Mumbai without permission. A bench of Justice Abhay Asok and Justice Ujjwal Bhuyan refused ED's plea, saying that bail was granted way back in the year 2018. And therefore, at this stage, there was no case for interference under Article 136 of the Constitution. The bench also disposed of a plea by Bhujbal against the Bombay High Court's 2016 judgment rejecting challenge to his arrest in the money laundering case. Let me tell you, Bhujbal is currently member of Legislative Assembly from Yola constituency. When the NCP split, he joined the Ajit Pawar camp to be part of the ruling BJP-Shiv Sena coalition. And lastly, the Apex Court has today issued notice in plea against the Gujarat High Court's refusal to quash an FIR against Congress MP and poet Imran Pratap Gari. The FIR was registered over an Instagram post featuring a video clip with the poem "Ek Khoon ke Pyase Baat Suno" running in the background. The poem, argued by Pratap Gari to be spreading a message of love and non-violence, allegedly contravened sections 196, 197, 299, 302 and 57 of Bharatiya Nyaya Sanhita. Section 196 specifically pertains to promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintenance of harmony. The Gujarat High Court had refused to quash the FIR, emphasizing the need for further investigation and citing Pratap Gari's non-cooperation with the investigation process as a factor in its decision. His counsel, Senior Advocate Kapil Sibal, questioned the High Court's decision to dismiss the petition without issuing a notice. After which, the bench of Justices Abhay Asok and Ujjwal Bhuyan issued notice and also granted interim relief, ordering that no further steps be taken in regard to the FIR till further orders. For more information on the cases discussed here, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel.